This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. The Anti-Federalist Papers. Anti-Federalist No. 6. Letters from the Federal Farmer to the Republican. Letter No. 4. October 12th, 1787. Dear Sir, it will not be possible to establish in the federal courts the jury trial of the vicinage so well as in the state courts. Third, there appears to me to be not only a premature deposit of some important powers in the general government, but many of those deposited there are undefined, and may be used to good or bad purposes as honest or designing men shall prevail. By Article 1, Section 2, representatives and direct taxes shall be apportioned among the several States, etc. Same article, Section 8, the Congress shall have powers to lay and collect taxes, duties, etc., for the common defense and general welfare, but all duties, imposts, and excises shall be uniform throughout the United States. By the first recited clause, direct taxes shall be apportioned on the States. This seems to favor the idea suggested by some sensible men and writers that Congress, as to direct taxes, will only have power to make requisitions, but the latter clause, power to lay and collect taxes, etc., seems clearly to favor the contrary opinion, and, in my opinion, the true one, that Congress shall have power to tax immediately individuals without the intervention of the state legislatures. In fact, the first clause appears to me only to provide that each state shall pay a certain portion of the tax, and the latter to provide that Congress shall have power to lay and collect taxes, that is, to assess upon and collect of the individuals in that state the state's quota, but these still I consider as undefined powers, because judicious men understand them differently. It is doubtful whether the Vice President is to have any qualifications. None are mentioned. But he may serve as President, and it may be inferred he ought to be qualified therefore as the President. But the qualifications of the President are required only of the person to be elected President. By Article the 2nd, Section 2, but the Congress may by law vest the appointment of such inferior officers as they think proper in the President alone, in the courts of law, or in the heads of the departments. Who are inferior officers? May not a Congress disposed to vest the appointments of all officers in the President under this clause vest the appointment of almost every officer in the President alone, and destroy the check mentioned in the first part of the clause and lodged in the Senate? It is true this check is badly lodged, but then some check upon the first magistrate in appointing officers ought, it appears by the opinion of the Convention, and by the general opinion, to be established in the Constitution. By Article 3, Section 2, the Supreme Court shall have appellate jurisdiction as to law and facts, with such exceptions, etc. To what extent is it intended the exceptions shall be carried, Congress may carry them so far as to annihilate substantially the appellate jurisdiction, and the clause be rendered of very little importance. Fourth, there are certain rights which we have always held sacred in the United States, and recognized in all our constitutions, and which, by the adoption of the new Constitution in its present form, will be left unsecured. By Article 6, the proposed Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. It is to be observed that when the people shall adopt the proposed Constitution, it will be their last and supreme act. It will be adopted not by the people of New Hampshire, Massachusetts, etc., but by the people of the United States. And wherever this Constitution, or any part of it, shall be incompatible with the ancient customs, rights, the laws, or the constitutions heretofore established in the United States, it will entirely abolish them and do them away. And not only this, but the laws of the United States, which shall be made in pursuance of the Federal Constitution, will also be supreme laws, and wherever they shall be incompatible with those customs, rights, laws, or constitutions heretofore established, they will also entirely abolish them and do them away. By the article before recited, treaties also made under the authority of the United States shall be the supreme law. It is not said that these treaties shall be made in pursuance of the Constitution, nor are there any constitutional bounds set to those who shall make them. The President and 2/3 of the Senate will be empowered to make treaties indefinitely, and when these treaties shall be made they will also abolish all laws and state constitutions incompatible with them. This power in the President and Senate is absolute, and the judges will be bound to allow full force to whatever rule, article, or thing the President and Senate shall establish by treaty. Whether it be practicable to set any bounds to those who make treaties I am not able to say. If not, it proves that this power ought to be more safely lodged. The Federal Constitution, the laws of Congress made in pursuance of the Constitution, and all treaties must have full force and effect in all parts of the United States, and all other laws, rights, and constitutions which stand in their way must yield. It is proper the national laws should be supreme and superior to state or district laws, but then the national laws ought to yield to unalienable or fundamental rights, and national laws made by a few men should extend only to a few national objects. This will not be the case with the laws of Congress. To have any proper idea of their extent, we must carefully examine the legislative, executive, and judicial powers proposed to be lodged in the general government, and consider them in connection with a general clause in Article 1, Section 8, in these words, after enumerating a number of powers: to make all laws which shall be necessary and proper for carrying into execution the foregoing powers, and all other powers vested by this Constitution in the government of the United States, or in any department or officer thereof. The powers of this government, as has been observed, extend to internal as well as external objects, and to those objects to which all others are subordinate. It is almost impossible to have a just conception of these powers, or of the extent and number of the laws which may be deemed necessary and proper to carry them into effect, till we shall come to exercise those powers and make the laws. In making laws to carry those powers into effect, it is to be expected that a wise and prudent Congress will pay respect to the opinions of a free people, and bottom their laws on those principles which have been considered as essential and fundamental in the British and in our government. But a Congress of a different character will not be bound by the Constitution to pay respect to those principles. It is said that when the people make a Constitution, and delegate powers, that all powers not delegated by them to those who govern is reserved in the people, and that the people in the present case have reserved in themselves and in their state governments every right and power not expressly given by the Federal Constitution to those who shall administer the national government. It is said, on the other hand, that the people, when they make a Constitution, yield all power not expressly reserved to themselves. The truth is, in either case, it is a mere matter of opinion, and men usually take either side of the argument as will best answer their purposes. But the general presumption being that men who govern will in doubtful cases construe laws and constitutions most favorably for increasing their own powers, all wise and prudent people in forming constitutions have drawn the line, and carefully described the powers parted with and the powers reserved. By the state constitutions certain rights have been reserved in the people, or rather they have been recognized and established in such a manner that state legislatures are bound to respect them, and to make no laws infringing upon them. The state legislatures are obliged to take notice of the bills of rights of their respective states. The bills of rights and the state constitutions are fundamental compacts only between those who govern and the people of the same state. In the year 1788 the people of the United States make a federal constitution, which is a fundamental compact between them and their federal rulers. These rulers, in the nature of things, cannot be bound to take notice of any other compact. It would be absurd for them, in making laws, to look over 13, 15, or 20 state constitutions, to see what rights are established as fundamental, and must not be infringed upon, in making laws in the society. It is true they would be bound to do it if the people, in their federal compacts, should refer to the state constitutions, recognize all parts not inconsistent with the federal Constitution, and direct their federal rulers to take notice of them accordingly. But this is not the case, as the plan stands proposed at present, and it is absurd to suppose so unnatural an idea is intended or implied. I think my opinion is not only founded in reason, but I think it is supported by the report of the Convention itself. If there are a number of rights established by the State Constitution, and which remain sacred, and the general government is bound to take notice of them, it must take notice of one as well as another. And if unnecessary to recognize or establish one by the Federal Constitution, it would be unnecessary to recognize or establish another by it. If the Federal Constitution is to be construed so far in connection with the State Constitutions as to leave the trial by jury in civil causes, for instance, secured, on the same principles it would have left the trial by jury in criminal causes, the benefits of the writ of habeas corpus, etc., secured. They all stand on the same footing. They are the common rights of Americans, and have been recognized by the State Constitutions. But the Convention found it necessary to recognize or reestablish the benefit of that writ, and the jury trial in criminal cases. As to ex post facto laws, the Convention has done the same in one case, and gone further in another. It is part of the compact between the people of each State and their rulers that no ex post facto laws shall be made. But the Convention, by Article 1, Section 10, have put a sanction upon this part even of the State compacts. In fact, the 9th and 10th sections in Article 1 in the proposed Constitution are no more nor less than a partial Bill of Rights. They establish certain principles as part of the compact upon which the federal legislators and officers can never infringe. It is here wisely stipulated that the federal legislature shall never pass a bill of attainder, or ex post facto law, that no tax shall be laid on articles exported, etc. The establishing of one right implies the necessity of establishing another and similar one. On the whole, the position appears to me to be undeniable, that this Bill of Rights ought to be carried farther, and some other principles established, as a part of this fundamental compact between the people of the United States and their federal rulers. It is true, we are not disposed to differ much at present about religion, but when we are making a constitution, it is to be hoped, for ages and millions yet unborn, why not establish the free exercise of religion as a part of the national compact? There are other essential rights, which we have justly understood to be the rights of freedom, as freedom from hasty and unreasonable search warrants, warrants not founded on oath, and not issued with due caution, for searching and seizing men's papers, property, and persons. The trials by jury in civil causes, it is said, vary so much in the several States that no words could be found for the uniform establishment of it. If so, the federal legislation will not be able to establish it by any general laws. I confess I am of opinion it may be established, but not in that beneficial manner in which we enjoy it, for the reasons before mentioned. When I speak of the jury trial of the vicinage, or the trial of the fact in the neighborhood, I do not lay so much stress upon the circumstance of our being tried by our neighbors. In this, enlightened countrymen may be probably impartially tried by those who do not live very near them. But the trial of facts in the neighborhood is of great importance in other respects. Nothing can be more essential than the cross-examining witnesses, and generally before the triers of the facts in question. The common people can establish facts with much more ease with oral than written evidence. When trials of facts are removed to a distance from the homes of the parties and witnesses, oral evidence becomes intolerably expensive, and the parties must depend on written evidence, which to the common people is expensive and almost useless. It must be frequently taken ex parte, and but very seldom leads to the proper discovery of truth. The trial by jury is very important in another point of view. It is essential in every free country that common people should have a part and share of influence in the judicial as well as in the legislative department. To hold open to them the offices of senators, judges, and offices to fill which an expensive education is required, cannot answer any valuable purposes for them. They are not in a situation to be brought forward and to fill those offices. These, and most other offices of any considerable importance, will be occupied by the few. The few, the well-born, etc., as Mr. Adams calls them, in judicial decisions as well as in legislation, are generally disposed, and very naturally too, to favor those of their own description. The trial by jury in the judicial department and the collection of the people by their representatives in the legislature are those fortunate inventions which have procured for them in this country their true proportion of influence, and the wisest and most fit means of protecting themselves in the community. Their situation as jurors and representatives enables them to acquire information and knowledge in the affairs and government of the society, and to come forward in turn as the sentinels and guardians of each other. I am very sorry that even a few of our countrymen should consider jurors and representatives in a different point of view, as ignorant, troublesome bodies which ought not to have any share in the concerns of government. I confess I do not see in what cases the Congress can, with any pretense of right, make a law to suppress the freedom of the press, though I am not clear that Congress is restrained from laying any duties whatever on printing, and from laying duties particularly heavy on certain pieces printed, and perhaps Congress may require large bonds for the payment of these duties. Should the printer say the freedom of the press was secured by the Constitution of the State in which he lived, Congress might, and perhaps with great propriety, answer that the Federal Constitution is the only compact existing between them and the people. In this compact the people have named no others, and therefore Congress, in exercising the powers assigned them, and in making laws to carry them into execution, are restrained by nothing beside the Federal Constitution, any more than a State legislature is restrained by a compact between the magistrates and the people of a county, city, or town of which the people, in forming the State Constitution, have taken no notice. It is not my object to enumerate rights of inconsiderable importance, but there are others, no doubt, which ought to be established as a fundamental part of the national system. It is worthy observation that all treaties are made by foreign nations with a confederacy of 13 states, that the western country is attached to 13 states, 13 states have jointly and severally engaged to pay the public debts. Should a new government be formed of 9, 10, 11, or 12 states, those treaties could not be considered as binding on the foreign nations who made them. However, I believe the probability to be that if 9 states adopt the Constitution, the others will. It may also be worthy our examination how far the provision for amending this, when it shall be adopted, is of any importance. No measures can be taken towards amendments unless 2/3 of the Congress or 2/3 of the legislatures of the several states shall agree. While power is in the hands of the people or democratic part of the community, more especially as at present, it is easy, according to the general course of human affairs, for the few influential men in the community to obtain conventions, alterations in government, and to persuade the common people they may change for the better, and to get from them a part of the power. But when power is once transferred from the many to the few, all changes become extremely difficult. The government, in this case, being beneficial to the few, they will be exceedingly artful and adroit in preventing any measures which may lead to a change, and nothing will produce it but great exertions and severe struggles on the part of the common people. Every man of reflection must see that the change now proposed is a transfer of power from the many to the few, and the probability is, the artful and ever active aristocracy will prevent all peaceable measures for changes, unless when they shall discover some favorable moment to increase their own influence. I am sensible thousands of men in the United States are disposed to adopt the proposed Constitution, though they perceive it to be essentially defective, under an idea that amendments of it may be obtained when necessary. This is a pernicious idea. It argues a servility of character totally unfit for the support of free government. It is very repugnant to that perpetual jealousy respecting liberty, so absolutely necessary in all free states, spoken of by Mr. Dickinson. However, if our countrymen are so soon changed, and the language of 1774 is become odious to them, it will be in vain to use the language of freedom or to attempt to rouse them to free inquiries. But I shall never believe this is the case with them, whatever present appearances may be, till I shall have very strong evidence indeed of it. Yours, and etc., the Federal Farmer. End of Anti-Federalist, No. 6.